Hello, and thank you for joining us this afternoon for our webinar on affirmative action with SACAC. We so appreciate you taking the time out of your day. If it's anything like Georgia, it's a little bit of a rainy day, and it's finally getting chilly here, so we're all excited that it's officially sweater weather. If this is your first time joining us for a SACAC webinar, there are a few things that you need to know. At the bottom of your screen, you'll see a couple of icons that you can use to control your experience. First, make sure that you're muted. That is the default, but just in case, you want to make sure that we don't hear the clicking of your keys. And second, you'll see an option for Q&A. This is where we want you to engage with us during the webinar. If you have questions that pop up for any of the panelists, whether it's something addressing that they've asked specifically or discussed, or whether it's a topic that's related but hasn't come up explicitly, feel free to put that question in the Q&A, and throughout the webinar, our panelists will be addressing those questions. We have a distinguished set of guests with us, and first, I'd like to introduce you to Dr. Doug Christiansen from Vanderbilt, who will be the moderator for today's panel.
Good afternoon, everyone. I'm so happy to see you. Let me make sure I can see you. Okay, just give me 1 second here. Okay, sorry about that delay. I guess I'm on. Well, good afternoon. As Aaron mentioned, it's a little rainy day here in Nashville, Tennessee as well. So we appreciate you taking 40 or so minutes with us as we think about affirmative action and the court cases from Bakke to present day in Harvard over the last 40 years. And hopefully we can impart some great information. Before I start, though, give you the lay of the land that I will have each of the panelists introduce themselves, give us a little of their background. And then I will spend about 10 or 15 minutes walking through and outlining each of the major cases. And then from there, we'll move into Q&A as we move through the process. And I'll ask some panelists to start our Q&A. And we really hope this will be interactive and that you will type in your questions as well. And so I'd first like to ask Ashley to introduce herself, then Brian, and then Bill, and a little bit of your background, where you're working, your titles, and then we will start off. So Ashley.
Hi, everyone. My name is Ashley Armato. I am the Senior Associate Director of College Counseling at Palmer Trinity School in Miami, Florida. I'm also the co-coordinator for equity inclusion here. I'm on the D&I committee for Access, and I'm also the co-leader of the SACAC Latinx SIG.
All right. Hello, everyone. My name is Brian Jackson. I am a former lawyer who specialized in education law, and now I teach government, economics, and U.S. history at Woodward Academy, a private K-12 school in College Park, Georgia.
Bill, are you there?
I am here. I'm not sure why I don't have a picture, but
You have to accept the video.
okay. All right, got it. Now I'm here. Great, thank you. I'm Bill Pruden. I am college counselor and director of civic engagement, and also a social studies teacher at Ravenscroft School in Raleigh, North Carolina. I'm another advertisement for non-lawyers. Like Brian, I have a law degree, but opted for teaching instead. So showing that difference, but this has always been an interest of mine, and I look forward to talking about it today.
Great. And as already mentioned by Aaron, I'm Doug Christiansen. I'm the Vice Provost for University Enrollment Affairs and Dean of Admissions here at Vanderbilt University, and also Associate Professor of Public Policy and Higher Education. So what I'd like to do is start off, and clearly we have a distinguished panel with everyone working with students, have been attorneys, in the college counseling ranks right now. So I think we've got really solid background. Both Bill and Brian obviously could jump in at any point and do what I'm going to do with their expertise of being an attorney. It's very important to know I am not an attorney. And I think for all of us, so you're aware, we're not giving any legal advice in this webinar. We're merely giving some thoughts and opinions and practices that we see. So it's just really important that you understand that this is not any kind of legal advice coming. It's merely to kind of help put construct around what we're talking about and hopefully have a great dialogue. So with that, I wanted to introduce a few words that will kind of lead us as we think through the court cases from Bakke to present day. And let me start with those, and I'm going to read a couple of definitions so that we have it very direct in your mind. First of all, strict scrutiny. And that's a really important word when we think about the use of race and how race is used in the admissions process. And so it's a legal term as well. And so strict scrutiny is the most rigorous standard of judicial review. It is applicable to race and ethnicity conscious decisions that confer opportunities or benefits because distinctions based on race and ethnicity are inherently suspect under federal law. To satisfy strict scrutiny, institutional policies must serve a compelling interest and be narrowly tailored to achieve that interest. So first of all, I want you to think about strict scrutiny, and we'll come back to that in a moment. Another definition that I want us to think about is a compelling interest. A compelling interest is the end that must be established as a foundation for maintaining lawful race and ethnicity conscious programs that confer opportunities or benefits. Federal courts have expressly recognized a limited number of interests that can be sufficiently compelling to justify the consideration of race or ethnicity in a higher education setting, including a university's interest in promoting the educational benefits of a diverse student body. So we've got strict scrutiny, highest of the judicial review. We have to have a compelling interest. And then the third definition I wanted to use as kind of a framework is narrow tailoring. And what this is narrow tailoring, refers to the requirement that the means used to achieve a compelling interest must fit that interest precisely, with race or ethnicity considered only in the most limited manner possible. Federal courts examine several interrelated criteria in determining whether a given program is narrowly tailored, including the flexibility of the program, the necessity of using race or ethnicity, the burden imposed on non-beneficiaries of the race ethnic preference, and whether the policy has an endpoint and is subject to periodic review. So if we think about those things now, and that's what I think about a lot, is the strict scrutiny the court puts on when thinking about affirmative action in the admissions process. Making sure there's a compelling interest within the institution that you work at, and also that it's very narrowly tailored. It just can't be a free-for-all. It's got to be a very narrowly specific, tailored process and approach. And thinking about that, I want you to kind of think if I had a diagram in front of me and we thought we're going to use race in the decision process, or one of the factors in an admissions decision process. And what you would really think about here, and this is just going to kind of reiterate what I've said, but if you're going to use race in the admissions process, your institution has to have a compelling interest. What is the compelling interest for doing that? And then, as I've mentioned, it has to be tailored in a very narrow fashion. Part of that narrow tailoring really looks at the necessity. Is it necessary? And that's a piece that has come up in the Harvard case of really looking at necessity. But is it necessary? Is it flexible? Is your policy flexible that you're looking for race-neutral approaches and not relying only on race-conscious approaches, meaning it's flexible and you're always trying to move to not using race in the decisioning? See, what is the burden, as I've already mentioned, is what is the burden to someone who does not receive that individual benefit? And does the compelling interest trump that, if you will? And finally, periodic review. As I've talked with a lot of institutions, one of the hardest things is this periodic review, as they set their process and then they do not look at it every year and throughout the year. And pretty soon they're 6, 7, 8 years into doing exactly the same thing, but they've not had periodic review to continue to see if they can move to a more race-neutral process. And that gets back to that highest judicial review of the strict scrutiny. So as we think about scrutiny, as I've mentioned, the highest would be when race or ethnicity classifications are introduced, and that attaches at the highest scrutiny. Intermediate scrutiny would be when you would look at gender classifications and use gender in an individual holistic manner. And then there's rational basis, if you will, and that's where all of the admissions offices in the country have to make some form of decisioning based on certain variables. And that is more rational. For a state institution, it may be deciding what criteria will be for in-state students or out-of-state students. It may be differentiating your requirements by major or school or discipline. It may be looking at students from various areas within your state or counties, making sure your counties are represented. And that would be a rational basis where you're not looking at a gender, intermediate scrutiny, or at strict scrutiny, really looking at in using race or ethnicity. So with that being said, let's kind of do a little historical walk as we think about Bakke, which just celebrated its 40th anniversary, and it was a landmark case in 1978. And basically, it was the UC Davis Medical Center, and the Supreme Court ruled it was unconstitutional to set aside 16 of the 100 seats for African American students. And looking at what was the goal of the UC Davis Med School's original goal, and I'm going to read 4 of those. It was to reduce historic deficit of traditionally disfavored minorities in med schools and professions. It was to counter the effects of discrimination by society. It was to increase physicians in traditionally underserved neighborhoods. And it was to obtain education benefits that are an ethnically diverse student body, So the regents, the Supreme Court, California v. Bakke, was found that they could not use a quota system and set aside a certain number of seats. However, what Bakke did do is it affirmed the use of race in an individual, broad manner, not specific, not to everybody in a particular race, but very individual. And so that was a really hallmark case of saying race could be used, but it couldn't be used in a quota system where you set aside. It had to be part of developing and building your community. From really there, and it came out and said you can't use a quota system. Well, then if you fast forward up to the 2 cases at the University of Michigan, and there are a few other intermittent cases that are throughout this process, but I'm trying to pick out the 4 major ones. If you go from Bakke that said race could be used, but not in a quota fashion, and you fast forward now all the way up to the Michigan cases. There were 2 Michigan cases, and in those cases, one was at the undergraduate level and one was at the law school level. And the outcome of the Supreme Court and the undergrad admissions policy struck down the decision. Points added for underrepresented minority groups or others was ruled unconstitutional. In the majority opinion for the undergraduate case, Justice Rehnquist wrote that the University of Michigan's undergrad policy, which automatically distributed 20 points or 1/5 of the points needed to guarantee admission to every single underrepresented minority applicant solely because of race is not, and so they had in effect, well, it was not a quota system. In a way, it was a de facto quota system or a point system that afforded a whole group the same benefit, not looking individually at context and their background. Now, if we take the same ruling or the same Supreme Court that year and look at then the law school case, the law school case was actually supported by the Supreme Court in that the law school manner. And so Justice Sandra Day O'Connor said this: the law school's interest is not simply to assure within its student body some specific percentage of a particular group merely because of its race or ethnic origin, which were prohibited by the Bakke decision in '78. racial quotas could not be used. The Law School gives a high level besides race and ethnicity that contribute to a diverse student body. So what was very really positive in that ruling was that affirmed the use of race as the Bakke did, saying but you couldn't use a quota, and then you couldn't use a point system, but it still affirmed the use of race in an individual holistic manner. Now, Sandra Day O'Connor also said in her ruling that the use of race should really, 25 years from the ruling of the Michigan case, using race-conscious admissions processes should really go away by 25 years, and that we will have worked to build our pipelines, we'll have worked to develop our processes in society that we've uplifted, and we would go to race neutral. So there, in fact, in my estimation, higher education got a little sleepy and started to and think, oh, we've got 25 years, we don't really have to be continually progressing to think about race neutral processes. And so about 7 or 8 years after the ruling, when people thought it might be up to 25, the University of Texas came along, and Abigail Noel Fisher, a white applicant, was denied admission to the undergraduate program at the University of Texas at Austin. She believes she was turned away solely because of her race, even though her high school record did not meet the criteria to guarantee admission. She was accusing the UT of blanket racial balancing. And the University of Texas system admissions policy automatically admits students who finish high school in the top 10% of their class, although there is a partial exemption at the Austin campus to limit that automatic admittance to 75% of the incoming class. For those who aren't in the top bracket, race is taken into consideration in an effort to diversify the incoming class. Fisher was denied admission and believes it was based on this policy. Fisher feels that if she were another race, she would have been admitted. Bill Powers, who was the president of the University of Texas, Austin, stated, "We have a holistic admissions process that helps us serve all populations of the state of Texas. It is very narrowly tailored and follows previous statements by the Supreme Court on how an admissions process meets our constitutional requirements, and will continue to make those points as we proceed with the litigation and best serve the people of Texas." UT asked the case to be denied because Fisher attended another university at that point, and they felt no material harm in the end happened. And that was denied, and the case was first heard by Justice Patrick Higginbotham in the Fifth Circuit Court, and he stated, "There was an elephant in the room at the top 10% law in a proxy for race, with a scattershot method for admission, a UT to UT that treats students from high-achieving high schools unfairly." So it was heard there, obviously from there, I mean, it was viewed, it didn't pass, so it went up to the Supreme Court. And on October 2012, the U.S. Supreme Court heard the case of Fisher v. Texas. It was discussed and determined that neither the schools nor the Supreme Justices had clear guidance from past rulings. So the U.S. Supreme Court ruled on June 24th of 2013 in a very narrow decision authored by Justice Kennedy, no ruling on the merits of the UT admission plan, and remanded it back to the Fifth Circuit Court for key questions that were left open. However, what the Fisher 1 case did is it preserved the Michigan and the Bakke notion of race is appropriate if used individually and holistically. Educational benefits of a diversity remain a compelling interest that can justify race-conscious practices. Some deference to educational institutions is appropriate for compelling interest analysis. So on July 15th of 2014, the Fifth U.S. Circuit Court of Appeals upheld the University of Texas admissions policy. And let me read this. "It is important because all of our students, regardless of their ethnicity or race, are going to be out in a very diverse world, both globally and within the United States. and working across lines of income, lines of ethnicity, lines of political and religious views, UT President Bill Power said, it is important that they have an environment on campus where they are learning to work across all lines. So on December 9th, 2015, the case returned to the U.S. Supreme Court. And on June 23rd of 16, the U.S. Supreme Court's second ruling in Fisher v. University of Texas with a 4-3 vote upheld the Fifth Circuit Court's prior decision. And let me give you some specifics here. The court's decision upheld and affirmed the prior court's ruling upholding the University of Texas race-conscious admissions program. In addition, the ruling provided insight regarding policy on this matter and key evidence, thus providing guidance to public and private institutions that consider race in an enrollment practices moving forward. This decision also upholds the legal framework of the Bakke case, the Michigan cases, and the Fisher one. It affirmed the educational benefits that flow from student body diversity are justification for race-conscious admissions processes, and UT's goals were clear and concise, same and consistent treatment of applicants in the holistic, allowing consideration of multiple factors and pieces of information to reach individualized judgment. The Fisher case is now finished, and there are obviously no more appeals for that. And the key takeaways from Fisher are this. Institutions of higher education that seek to achieve the educational benefits of diversity should focus as deliberately on race-neutral practices as they do on race-conscious practices. It's not either or, potentially it's both and. So it was we got more guidance of being able to push that we need to be thinking about race-neutral practices, and we can't just rely on race-conscious practices. Evidence of institutional practice that exhibits institutional policy should be compiled and evaluated as part of an institution's periodic review of race and ethnicity conscious policies. So that was really saying we've got to have evidence, and evidence from our own institutions, not global national evidence, but evidence that are at our own institution, that the policy is helping our learning outcomes. The concept of critical mass remains as a viable contextual benchmark of success, but more robust practice-oriented research and program evaluation is called for. So very quickly to summarize, the quota system, unconstitutional, but the use of race individually in the Bakke case. The point system in the Michigan undergraduate found unconstitutional, but the law school found constitutional and a highly individualized holistic review. And then Fisher reaffirmed that by the time we got to Fisher 2 of the importance of being able to use race, but you must have evidence to support the usage of that. So after the Fisher case, we now fast forward to 2014, and there was a lawsuit filed against Harvard, as you all know, and it was that Harvard had discriminated against Asian Americans in their admissions process. As a side note, UNC also had a lawsuit filed against them that was similar in nature, but the lawsuit was that the Caucasian students at UNC had been discriminated against. As you know, the Harvard case just ended. We don't have a ruling. The last I've heard, the ruling won't come out till the beginning of the year, but I don't know how solid that is. You just read different reports and hear that, so it could be any day, but my sense is it might be a little later. And the Harvard case, as you all know, just finished, and we will wait to see what happens with that. It will be very interesting in the Harvard case to think of option one, that nothing happens, and this is at the circuit court in Boston, or the federal court, excuse me, and that will they overturn 40 years of precedence of the Supreme Court? We don't know. Will they look at some of the practices by Harvard perhaps as not individualized enough? We don't know what they will do, or will they simply reaffirm and do nothing? So all those types of things are still in the process that would be coming out. So with that background and backdrop, I'm sorry that was, I know, probably a little boring and dense, but I wanted you to make sure that we had that whole framework. I wanted to go to Brian, if I might. And Brian's background, obviously being an attorney and now a current faculty member and teaching U.S. history and government. I wanted to go to Brian and say, Brian, it seems as though universities are preparing for the end of affirmative action due to the most recent court case. How does the Harvard case differ from the previous affirmative action cases in your mind? And what are the contrasts or differences of what might happen with Harvard?
All right. Well, the similarities are self-evident. With all of these cases, you have a plaintiff essentially claiming that the university or college is discriminating against them on the basis of their race in violation of the U.S. Constitution, 14th Amendment, or some other federal law. What makes this particular case at Harvard different in comparison to the Bakke ruling or the Grutter ruling or even the Fisher ruling is that you have plaintiffs who actually are people of color. All right, historically, these affirmative action cases have been scenarios in which you have white applicants to colleges and universities and medical schools and law schools who have been denied admission and claiming that they've been denied admission because they are white, in favor of the lesser qualified African American, lesser qualified Latino student. In this case, though, you sort of like have flipped race flipped race around. All right, in which you have a group of Asians who are claiming that, well, no, Harvard is discriminating against me precisely because I am Asian in favor of the lesser qualified white students and other students of color who are not Asian. And I think that presents a potential for a wedge issue in the sense that you are having people of color arguing against other people of color. All right, whereas historically it has been the dominant majority white applicant arguing racial discrimination in favor of people of color.
You know, I think, Brian, I think that's an excellent point as you bring up that the first time where we really have another group other than Caucasians pursuing this and then trying to balance this whole affirmative action piece, I think that's a very solid contrast of kind of what we've had in the past till now. One other quick question I had for you, Brian, is kind of just to go along with this. As you think about the Michigan case, the undergrad case, or the law school case of kind of individualized holistic admissions, as you think about the Harvard case and what you know about it, do you think they've veered perhaps a little from an individualized and more systematic, or is there just not enough knowledge from the court for you to answer that question?
Actually, I can, I wasn't, of course I'm not there, I wasn't present during the trial, but based upon the reports I've heard and the interviews I've heard from of the plaintiffs, et cetera, Harvard is arguing that it does use this, this holistic, individualized approach in determining which students it accepts and which students it does not. The plaintiff's argument, however, is that, well, that's not really true. They're arguing essentially that Harvard is using a quota system, and then once they reach a certain level of Asian applicants, per se, at that fixed ceiling, then no more Asians need apply. Essentially, that's what they are arguing that that's what Harvard is doing. Of course, Harvard denies this and is saying that they use this holistic approach. Now, to the holistic approach argument, then the plaintiffs then are arguing that there's this one piece of the criteria that Harvard uses that's part of like a personal score, a personal admission, interpersonal admission point. I don't know how they to be articulated, but something of that nature. And that as a historical matter, Asians don't, that's their argument, that Asians don't score as well as other applicants in the personal admission rating. And that what this really is subterfuge. This is a guise that Harvard is using to discriminate against Asians. That's their argument. And we'll see how convincing they were at trial in proving up to the courts whether or not Harvard actually does have a quota system that they don't advertise, or whether or not their purported holistic, individualized report, which uses race as one factor of many, is just really subterfuge for actual racial discrimination against Asians.
Good. Thank you, Brian. Excellent response. You know, Bill, I wanted to come to you kind of along the same line here a little bit and ask you, and again, I know you weren't at the trial. I know you're an attorney and you're not giving legal advice here. I'm really asking kind of from your experience and background. So in your opinion, do you think the Harvard lawsuit has made the case to maintain affirmative action practices in admissions? Basically, I'm saying, what do you think, what's in the crystal ball is going to come out from the federal court in Boston?
Well, I think it's real hard to really make that kind of prediction, but I think the Harvard case is really a kind of logical next step in the way this is unfolded. You did a great job of kind of covering the legal evolution of this whole process. It actually, you know, we tend to forget affirmative action started having nothing to do with education. It was 2 executive orders by Presidents Kennedy and Johnson that really, Kennedy's preceded the Civil Rights Act. Johnson's refined it a little bit in terms of trying to prevent discrimination. And then we first get the approach to education with Bakke. I think you would argue that, as you noted, Bakke had a different goal than I think we're talking about now, as they very much clarified it was to try to make up for past discrimination, as were the affirmative action executive orders. And the court said it's not an illegitimate goal, but you can't do it by setting it aside. And so I think we've in turn moved into the more holistic approach that includes everybody. I mean, under Bakke, you had 2, as UC Davis acknowledged, 2 very different, separate admissions processes. There was the 12 spots, I think it was, and 16 spots for African Americans, and then there was the rest that Bakke was thrown into. And so that changed it. As we've gotten into holistic, we've gotten away from the producing enhanced opportunities, and we've been talking significantly more about a different goal, and that is the idea of diversity, what diversity brings to the educational process. And now with Harvard, we've got, all right, we have a diverse group. Are we going to limit part of that? And as I think Brian said very appropriately, this has a different set of combatants, if you will, in terms of people of color against arguably people of color or against whites. And I think that complicates it. As I said kind of in my intro, I got into education in part because I felt like a lot of the legal stuff was there. I went to law school intending to be a civil rights and civil liberties lawyer, and sort of felt like, even though Bakke had just been decided when I started, that it was kind of there in the groundwork, but that there was an element of an understanding of history and an attitudinal aspect that was going to be necessary for the next step. And I'm not sure that we have, nor did the Harvard case advance as much, a real understanding of what we were trying to get out of this. And if you go back to Grutter, some of the most compelling amicus curiae briefs were from the military and from corporations about the importance of a diverse workforce, of the diverse educated workforce coming out of those schools. And that was why the Michigan policies needed to be had. So to me, that's kind of where we are. Harvard is kind of a logical next step in some respects as this has evolved, but it's also a very different one. It's not a real continuum that says, okay, we've done this, we've done that, so the logical next step is how this is going to play out.
Yes, very, very interesting. A question I have, maybe, Bill, if I could just get your thought on this. Why do you think Harvard was chosen versus a public institution, which traditionally we've seen more of? And wondered what your thought on that might be.
It's an interesting question. I think it's in some respects, my feeling is that they almost miscalculated. I think, you know, we all know Harvard is Harvard, as we often say, certainly in the college counseling side when, kids are throwing it out there as prospective choices. It has an aura, it has a history that is unrivaled, and I think there is a feeling oftentimes that, if you can slay that dragon, you potentially open up opportunities for further advancement, which everybody has said, or lots of commentators have said, this is about more than just this case and Harvard. On the other hand, in that same vein that Harvard is something of an outlier. I think most of us in other universities are like, no, we're not Harvard. We do our thing because we don't have it, whether it's resources, whether it's history, or what have you. So my gut feeling is that had this same case been filed against somebody else, it would not be getting the attention it is. And I think in this day and age, litigation of this sort is aimed at as much at a broader audience than it is at a jury or a judge.
Actually, and Brian and Ashley, I'll get right to you. I wanted, Brian, if I could pop back to you just briefly and ask you kind of the same question that I just asked Bill. From a constitutional theorist approach, would you have a sense of why they chose, from a legal standpoint, maybe why they chose Harvard as opposed to a public institution? Because that kind of attacks different questions, I think.
I believe that they, chose Harvard because Harvard is one of the most selective universities we have in America. And the idea is that if you can use Harvard as a paradigm for all universities, if your goal is to end race-based affirmative action or end using race as the factor in admissions, if it happens at Harvard, then you know that all the rest of them are also going to go by the wayside as well.
Right.
I also think that, especially, in our communities at large, many students aspire to attend Harvard, and so they believe that, if you can show that Harvard has a history of discrimination on the basis of race, then that could be a building block for taking out all race-based determinations.
Processes, yeah.
All processes, not just in education, but
across the board.
Across the board, this could be the landmark Supreme Court case, which will end affirmative action as we have known it for the last 40 years.
And I really liked your point, not just categorized in the education arena, but it could be in employment, it could be in contracting, many others, if something were to go, depending on how far it goes.
Correct. And and really quick, my personal opinion is, regardless of who wins this case in Boston, whether it is the Asian applicants or whether it is Harvard, the case will be appealed. And eventually, I think it's inevitable that the Supreme Court is going to have to give more guidance specifically as to whether or not affirmative action is going to continue, and if so, what are the precise criteria upon which race could ever be used as a factor in admission or employment or in contracting or whatever.
Right.
So this is not going to be the end all and be all, regardless of the time frame of the outcome of this case.
Exactly. Excellent points. Now, Ashley, coming to your role in school, college counseling, and you're talking with parents, you're talking with students, and all of that. So a question I have, in your experience, are students and parents keeping informed about the Harvard case? And do you think they're concerned about its effect on their applications for college admissions, whether it is using affirmative action or not? What's the scuttlebutt happening in the high schools about this topic?
I would say at this point, since this has become such an anxiety-ridden process, they're really paying attention to anything that has college admissions in the headlines. I'll say in particular in my community, parents haven't brought it up often. They know about affirmative action, obviously, and they understand that it plays a role in the college admission process. But students in particular have talked about it. I think comedians online, there's Netflix specials talking about affirmative action and jest, and Hassan Minhaj, actually, who was on The Daily Show for a long time, has a new Netflix show, and he dedicated a whole episode to this case and to what it means. So they're talking about it for sure. I would say particularly students who are social justice minded and value diversity and inclusion worry about what that's going to do if they do end affirmative action, what that will do to campus communities and communities of color. My Black students, my Latinx students, my Asian students wonder if they'll go from being maybe one of 5 students of color in a classroom to 1. And they're going to be the only one being referenced, and everyone will look at them when they talk about things like slavery, immigration, or, Donald Trump's rhetoric on Spanish and Mexicans. And they, fear that that might be the case if affirmative action prevents students of color from entering colleges because of that. I'm also in Miami. It's a majority minority community. So although I would say that all students do benefit from affirmative action because in the classroom and their social benefits, my Hispanic and Latinx students in particular wonder what that will do to admissions and the trends that we typically see and the type of students who are able to get into certain schools. So they're worried about that in terms of demographic diversity efforts. And then I would just put a plug in to say that it's really important for all of us, particularly on the high school side, to talk to our students and make sure that we're having conversations with them about affirmative action. I can't let a student just think that because they're checking a box that gives them an into a school, or let other students think that because other students are checking boxes, they're getting into schools only because of that. I feel that I really do need to protect my students of color in that aspect, because a lot of times people try to belittle their accomplishments and their achievements. So I think we need to be really careful. And although these are typical conversations, depending on, where you lie in terms of thinking that the way that affirmative action plays out right now is accurate, or it should be changed, it should be more socioeconomic driven. But regardless, we need to protect our students and make sure that they're not being spoken about, in bad ways because of how it seems to benefit some students and not benefit others.
Thank you. And Ashley, I'm going to come back in just a moment and ask you a question, but I wanted to bounce back to Brian. And Brian, a quick question for you. In your history courses and in government that you teach, could you give us a sense of what you think your students think about universities using race in the admissions process? I suspect you've probably had some lively debates. And is it, where do they sit? Where do you think this generation sits on this topic? And I know it's a unit of analysis of one classroom or yes, but what's your thought on that?
Based upon the courses that I teach, my belief is that the African American and Latinx students are generally in favor of race-based admission policies as a remedy for past discrimination, and the majority of my white students are against race-based admissions policies. And then the interesting thing, I think, concerns my Asian students, because I have Asian students who actually are divided on the issue as to whether or not race should be used as a factor. And I think this all sort of like goes down to what you believe benefits you individually. And so for the students that I teach, I think it comes down to, it really just comes down to does this policy benefit me? If it does, I'm in favor for it. Does the policy not benefit me? If it doesn't, then I'm against it. And I try to intimate to the students that this is bigger than just you, but I'm dealing with a certain population of students who are trying to get into the college of their choice, and they're not really concerned as much, unfortunately, with the larger policy implication issue. They're more concerned about their own individual, am I going to get to the school that I want to get into?
Mm-hmm. As we think about Ashley's notion that she made about students wanting to make sure that those that are of color are, maybe their achievements are belittled, as she had mentioned, and think it's just this. Is there a sense that in your world that the use of affirmative action is really at a zero-sum level, who gets in and who doesn't get in, and the notion of educational benefits of having multiple people with different backgrounds and experience really lead to educational benefits, and that students maybe now are just more focused on the get in and not get in and not really seeing that broader term. What are your thoughts on that? And then we'll go to Ashley.
Yes. They don't, like I said, I don't think they look at the broader implications. And as long, let me rephrase. Regardless of which student I'm talking about, they all recognize and they all at least state that they want a diverse society, they want a diverse campus, they're interested in things of that nature. All right. But when and they all recognize that there's a benefit to that. All right. It's just that they believe some of it should be able to be achieved without using race as a factor. That you can have diversity without affirmative action programs. And there's other students who are, who believe that, look, this is one way of many for which we can get a diverse society, and that door should not be closed, especially considering the history of racial discrimination against these same students on these various campuses.
Thanks. Ashley, kind of the same question back to you, thinking about your students and about educational benefit versus kind of this notion of getting in or not getting in. Are we moving to a broader spectrum with our students today, or is it really stuck at that get in, not get in their thought process of what affirmative action does or does not do?
I would say it's all relative. I think when they're in the thick of things and the process, they're very, egocentric, and they're thinking about themselves and how this will play out for themselves. I think because so many of our students are considered students of color in the application pool, so many come from different countries. We have an ESOL program as well. We are a global traveling school. Our students do really understand, I think, the benefit of interacting with people who are different than them. And for our white students who tend to have the more difficult time processing why this isn't a fair process for them, that's a lot of the language that they use. And I'm very quick to tell them that college admissions is not fair by the metrics that they might attribute to it. But they have so many friends and kids that they've known their entire lives who do, quote unquote, benefit from affirmative action because of their race or ethnicity, that it is hard for them to say that certain people don't deserve to get into certain schools. I think they end the process wishing that they too were able to get into those schools as well, that there was room for them. But at the end of the day, I think as many of us see, we're really able to, at the end of the process, people are where they want to be. And I think that they're able to look back and reflect on the process and where everyone was able to get in, understanding that everyone's where they should be, and kind of understanding that on a larger scale, diversity is important and being in these communities is important. That's a sense that at least I typically get from my kids.
That's good. Thank you. As we think about the 3,800 or so thousand colleges and universities in the United States, there is room for all of our students, but sometimes we get so focused as a country and as in high schools of there's only a certain group that it must be better, and so everyone's vying for there. And we've got to change some of the narrative that we have so many great schools and get away from this pecking order a little to understand there's greatness, and it's not always just if you're the top 10 schools or top 20 schools, and that to broaden that thought process as well. I have a few questions that have come in from our audience, and this kind of will be a little bit of a twist, and I'll throw it to you, Bill, first. And it says on here, what is your opinion on the use of legacy status used for admission as it relates to the most recent Supreme Court cases, or what came up in the Harvard case, in particular, a little bit about legacy? And what's your thought about that?
Well, I think legacy is, equally controversial, but again, I think it's reflective of arguably the business side of the college process. As Ashley said, I think all of us who are in this business have to remind the kids that the process is not fair, definitive, based on the kind of metrics. There are a lot of factors that go into it. For every legacy case, you can argue that there's an athletic piece that is no less critical. So, you know, there's a growing talk about or adding socioeconomic to the diversity pool as we talk about that. And I think the legacy piece is one that runs directly counter to that. And I think it's, you know, it's an important discussion. But I think, again, each school is looking at what they need as a community. And I think it's going to vary from school to school.
Good. Thank you for that. A couple of things I'd like to mention here quickly is, for those of you that are listening, really great resources. If you go to the College Board website and or type into Google Access and Diversity Collaborative, that is a great website that has great publications and information to really think about the court cases, how to think about, there's a playbook in particular, they call it, of how to think of your admissions office moving from as race conscious to how do you move it to race neutral. But it's a great resource, and it's the Diversity Collaborative, sponsored by the College Board, and it's a great resource that I think would be very helpful. And I just wanted to throw that out there as a resource for you to look at. And another question I wanted to bring up that was from one of our sorry about that, listeners, whatever we're doing here on the webinar, is I wanted, and let me read this, and Bill, I'll come back to you to kind of get your thoughts on this, and then I'll have a final quick question for Ashley, and then it looks like we'll be out of time. Here's what Brian, the person asked. Why doesn't choice of major or division ever seem to play a role in affirmative action discussions? Admissions officers must steward and align resources, which includes finding students for tenured faculty to teach, especially in underpopulated departments. What appears as anti-Asian, Asian American is perhaps a correction for oversaturation in STEM compared to the social sciences and humanities. Brian, what's your thought on that?
You want Brian or me?
Or Bill, go ahead, then I'll throw to Brian. Go ahead.
I think, again, that's a school issue. I mean, as a college counselor, you know, we deal with a lot of kids for whom they are applying and their major is totally unrelated. The school doesn't even ask, or if they do ask, it is strictly to get some information for their own data, whereas you get other students who are applying very definitively. We have the contrast right here in Right Triangle, North Carolina State. Ask, you apply very definitely to particular programs. UNC Chapel Hill, it has no impact. So I think it's less a question of an admissions broadly approach that would lead into potential discrimination or decision making than it is just an approach that the school chooses to pursue.
Brian, any additional thoughts on that?
I mean, I would co-sign to everything that Bill said. I would also suggest that that students apply and they say they want to major in one thing, and then they get there and they change their mind, and they're of course free to do that. And so I'm not necessarily certain that, you know, even if you have admissions policies or a question regarding what major you want to do as part of the admissions process, that it's going to be that way continuously all 4 or 5 years you're at the university. And so I'm not necessarily even sure like that is even, you know, relevant in terms of admission to the school itself, because once you are in, you are free to change your mind on your major, and that happens frequently.
Right. And part of obviously school and going to college is that exploration component too, as you know, and thinking about exploration and being tied into one versus exploration. I just think this person who wrote was really kind of bringing up the emphasis of STEM and what's happening in tighter areas and what effect does that have. So very interesting question. And Ashley, as we finish up in the last minute and a half with you, as you've listened to our whole conversation today and you've participated in that, I wondered from your vantage point of being a college counselor in Miami, what advice would you have to all of our people viewing this and participating today as you think about just inclusion, the importance of inclusion, the importance of hearing different voices and thoughts? And as I think about of your background and what you're really doing, a coordinator of equity and inclusion, I think is a really important thing. Just wondered if you could summarize kind of your thoughts as kind of the final words for today.
Well, I would say if you're not doing any inclusion work at your school, if you don't have courses, curriculum, programming that gives students the opportunity to have these conversations with adults around to help facilitate that, I think you need to, because whether or not affirmative action continues, our students are going off into college. I actually just came back from a fly-in where the school was very transparent about their diversity and inclusion efforts, and had us speak with student panelists who were working with their diversity center. And they talked a lot about, they have a really great freshman kind of inclusion course that all freshmen are required to take. And the faculty spoke very, very highly of it, and it sounded great, but they tackled really difficult texts like Ta-Nehisi Coates, for instance. And a lot of the students of color talked about not only their professors struggling with facilitating those conversations, but also facilitating the students not having any background in having these conversations. So that really made an impression on me and the work that we have to do on the high school end when it comes to making sure that our students not only know how to have these conversations, but they can have them in respectful ways, because they're going to be in communities where they're going to be with people they haven't seen before and haven't interacted with before. So we need to make sure that we're doing our part on our end so we can send them off to all the college folk a little bit more aware and less ignorant.
Good. Thank you so much. That was a great summation response. And I want to thank our panelists. Brian, excellent job. Bill, superb. And Ashley, wonderful. And I really appreciate you all participating today. And with that, we will finish up right at 1:30 on the nose.
Thank you.
I hope you all have a great day. Thank you.
Thank you.
Thank you.